can be a federal offense. It may be that that works. It may not be that that works. It's an undecided issue under New York law. So when we first looked at it, we saw, gee, there's a real risk here, a legal risk, that if we bring felony charges, they'll be reduced to misdemeanors. And we're investigating a whole slew, as you mentioned, of other felony charges. So the first time in my tenure when this came up, we took the decision, let's table the hush money situation. We referred to it in the office internally as the zombie case because it rose from the dead, went back into slumber, rose from the dead, and this happened a number of times. So we decided to keep the zombie case in the grave for the moment until we got further down the road of investigation. Then toward the end of the investigation, as I've said, we intended to join those charges with the more consequential charges that we hope to bring regarding the years of false financial statements.
I mentioned in the introduction that there were at least 9 different sort of criminal areas of inquiry about potential criminality that the DA's office was looking into at the time that you joined. You say one of them was the hush money payment to Stormy Daniels. Another one was taxes, potential improper business expense deductions, deductions of consulting fees. In his relationship with Deutsche Bank, could he have defrauded Deutsche Bank by getting financing through overstated financial statements? Whether he'd engaged in money laundering through Deutsche Bank using overseas bank accounts, the accuracy of materials he provided to the GSA about the old post office, and a host of other things, including insurance fraud, the restructuring of his loan on his Chicago skyscraper. You go on and on and on. When you describe that litany of areas of potential criminal inquiry for Trump, and when you describe your reasoning and the debates between you and your team about the hush money thing, are you giving a potential lifeline to Donald Trump's defense lawyers that if they do end up getting charged with anything related to any of those items, including the hush money matter, that your book could be used as evidence, essentially, to try to question the charges in court, to say, look, prosecutors have been looking at this stuff for a long time. Responsible prosecutors looked at this, decided there was nothing there, and didn't charge it in the past. This is selective prosecution, or this is an overreach. Have you given the defense a leg up here?
Look, I don't think we've given the defense any kind of leg up. When you look at the public reporting about the grand jury presentation that may now be underway, obviously I don't know what's going on behind closed doors in the DA's office, and I don't know what evidence is being presented. I don't know whether charges will be brought. But as it relates to the hush money circumstances, those facts have been known literally for years. Michael Cohen wrote about them in his book. He testified about them. Stormy Daniels wrote a book. Stormy Daniels appeared on Michael Cohen's podcast to talk about it. And the federal prosecutors brought their own prosecution based on those facts. So I'm not letting any cats out of the bag, if you will.